Okay, and then just want to share this screen here. Okay, so when I share this, it should end up being that the slideshow is what you're going to see. And I'll get this going here. Okay, great. So you should have received this, like I said, in an email. And if for some reason you need it again, just let me know. Rich and I, like I said, have historically done this program a couple times a year. So certainly if you missed this opportunity, you can't stay on for the full thing and you want another live event, you can sign up for the next one that we have, which will be in the fall. So that's going to be another option for you. So just getting started here, I'll take you through the slides, and the first couple are not incredibly interesting. It's just images of what Rich looks like in case you ever need to encounter Rich and all of his accolades. Obviously, you can see he's been doing this for quite a while, and he's really achieved a lot in the practice. So great guy to work with, very, very knowledgeable. Hopefully, if you are dealing with him, you do feel very comfortable dealing with him. So that's him there. Then myself, and then also our associate, Cynthia Hand. For those who have dealt with our firm a little bit, Cynthia is a newer addition to the department. She's an experienced estate planning attorney. So she's been practicing in estate planning for several years now. She was just previously with a different firm, and then she came to join us, which I'm very, very excited about. I've wanted her to join us for a good long time here. So she's great. She knows our processes and all of the things. So if you do have questions or you are beginning to need some assistance with your loved one's plan, then she is also someone that you can consult with and defer to. Okay. All right. So, and again, if for some reason you're not seeing the slideshow, maybe just pop a little note in either the Q&A or the chat box and let me know that that's the issue. On my side of things, it's like a million boxes are open. So I'm hoping you can see it. So when we're talking about estate planning, often our clients are coming to us with some specific goals and concerns. And you, on the other side of things, may maybe feel relieved that your loved ones have done some specific estate planning. And hopefully after today, you feel even more relief because our process is a lengthy one, but it's very thorough. There's a reason that we have our system in place. We are hoping that all of the possibilities are going to be addressed. They're going to be covered. So your questions today might be, what are my loved ones doing? Have they done planning? And if you're attending this webinar, it means that they have done estate planning, and it's probably a very thorough plan. And then also you might be wondering, how am I involved? And chances are, again, if you're on this webinar, it's because your loved one, your parent, or whoever it might be, has indicated to you that it might be a good thing to attend because you are involved in the documents in some way. And while you may be grateful or thankful or feel honored that you were listed in those documents, what that's actually telling you is that you're going to have some work to do at some point if your loved ones or your parents begin to decline or they pass away. So while it's a good thing they've done planning, hopefully this does get you prepared for some of the work and the tasks that you may be looking ahead to in the future. So like I said, it's great news because you are involved. There is a plan in place. Hopefully I can give you some of the answers, some of the information today. So when we're doing estate planning with our clients, we kind of operate off of sort of a general definition that helps us to hit all of the highlights, the primary goals and concerns. So when people are working with us initially to set up their estate plan, and then even on a year-to-year basis to maintain their plan, typically some of their focuses are the ability to control property while they're alive and well, right? They want to retain that management, that control. They don't want to give it up too soon. This ends up being a concern for a lot of our clients. They want to make sure they have a plan in place, but they don't want to turn over the keys to someone until they really need that level of assistance. So their plan probably has a plan for that. Plan for themselves and their loved ones if they were to become disabled. So we definitely want to include disability or incapacity planning as part of our estate plan. It's not just after death planning. And what I think you'll find, or maybe you've lived through this before, is that often the tasks and assistance that someone's going to expect of you if they do become incapacitated is going to be more arduous than after death, what you're expected to do. So certainly we have a lot of planning documents and mechanisms in place for incapacity, and maybe even not necessarily incapacity, but general disability, something that's preventing your loved ones from doing the things that they were previously doing. Usually financial management is what we're going to be planning for there. So if we are looking at a basic estate plan, many times those plans are going to involve trusts, even though what I'm describing to you is a very straightforward or common arrangement, family situation, financial situation, etc. We do encourage the use of trusts here because they do so many more things, and it is the kind of tool that gives us the highest guarantee of success. So while not all of our clients have trusts, chances are you're joining this workshop because there's probably a trust involved. On the screen should be an example of a revocable living trust. That's what the RLT is going to stand for. And in a revocable living trust, there's a lot of flexibility. And in this trust, there are, I would say, the most number of provisions that go into addressing disability, incapacity, and then after death. So in this instance, we have a revocable living trust. And while your loved one, the trust maker, the person creating the trust, is alive and well, they are going to be controlling their own trust instrument. So they're going to be the trustees of the trust. The trust is generally going to use their social security number, even if it's a joint trust. So sometimes between spouses, and I would say more common now than it was previously, we have one trust for both spouses. Even in those instances, we have provisions in the trust that describe that either spouse's social security number can be used as the tax identification number for the trust. Where this allows us to retain control is for all tax reporting purposes, for all assets that are associated with this trust. All the income is still going to be reported on the trust maker's income tax return. So it doesn't change anything regarding tax filings or anything like that. So they're retaining full ownership over the assets for tax reporting purposes, even though their assets on the bank statement or on the deed to their house, it might say that this revocable living trust is the owner. So technically speaking, if you don't have experience with this, when we set up this revocable living trust, it's a stack of paperwork. And when we are, I'll say, associating assets with this trust, we're typically doing that by going to the financial institution and changing the ownership on the account to name the trust as the owner. So if it was mine, it would be the Megan Conroy Living Trust. And I'll make the Megan Conroy Living Trust the owner of my checking account, savings account, my life insurance, my house. On things I don't want to make the trust the owner of, maybe I still want to tie it to my estate plan by using beneficiary designations. So maybe on my retirement accounts, which we don't want to change the ownership of, I'll say the Megan Conroy Living Trust is the beneficiary of my retirement account. And that designation is what allows this trust to control the distribution, to create the layers of protections that we are looking for when we're using these mechanisms. So here, the trust maker, let's say it's Megan Conroy, trust maker, creating the trust. I retain control because I'm the trustee. I also retain some level of control even if I became incapacitated. Just want to see if okay. Even if I became incapacitated, because I'm going to have in place a disability panel, a panel of people that I trust, who, if they know me well, and they have some concerns about my ability to and I just want to be able to use the laser pointer on this. My ability to manage my own affairs in my capacity as the trustee, my panel of trusted people can come together under the terms of the trust and say, you know what, Megan's been acting very strange, and I heard that she might have been clicking on some emails and tended to believe that maybe she won this inheritance from some other country, and I have some concerns that she might be a danger to herself financially at this point. If my panel members talk about that and they agree to that, they can actually remove me as the trustee of my own trust to protect me from myself. So typically we don't want to have to resort to this, but it does come up. And I will tell you something that I think is worth you knowing about. And we do try to have these conversations with our clients, but you should be very aware of what your loved ones' personalities are like. And as they change, as they get older, be aware of warning signs. The scams that are out right now, and I guess they have been for a while, but especially right now, they are very convincing. And I am getting more and more phone calls every single week of clients who have been scammed out of very large amounts of money. And it's only brought to their loved one's attention after it's too late. So just pay attention to those things. Have the conversations with your loved ones about what a scam might look like. And actually, New York State Department of the Aging, they have a really good website online. I recommend that you check that out. Maybe we can even get it up on the website at some point. But Department of the Aging has a great website that's specific to scams. And there's training videos that your loved ones can take to caution them about the different kinds of scams or how they may appear. And there's even some apps for their phone and like AI features on their phone to alert them if something might be a scam. So that's the key function of the disability panel, is to protect the trust maker from themselves if they start to lose the ability to determine what's a good financial decision and what maybe isn't so great. Or maybe they just stop taking care of their finances, which sometimes happen. So the panel is there to protect the trust maker from themselves. We feel like the trust maker has retained control, though, because they said, so if I'm setting this up, I said, okay, at some point in the future, if I start to suffer from diminished capacity, these are the people that I trust the most. These are the ones that if they said Megan should not be the manager of her trust, she should not be the trustee, these are the people I would want to make that decision for me. So while they're not in control at the time, they've lost the capacity, they've retained some semblance of control because they've determined who they trust enough to remove them from the position. And then they're also going to determine who their successor trustees are. So it's not that the incapacity panel gets to choose the successor trustees. Already written in my revocable living trust is going to be who takes over that position, that manager position for my finances, for my trust, if I'm not able to do that for myself. So again, retaining a little bit of control the best that we can. Okay. So in the trust document, and more sort like this green box that we have on this screen, in the trust document, we're going to describe what it is to be incapacitated, what is going to be the definition. And so on your screen right now is going to be an excerpt from a trust that describes what incapacity means and how a panel would go about determining whether or not the trustee, the trust maker, is incapacitated. So this can be done with any number of people to serve on the panel. All the stuff you're seeing here, these are not real client names or children names or anything like that. They're just swapped out. Usually we use like Sally Sample, but this one looks more convincing. It's not a real client name. So you're going to see the panel, and they can do this by unanimous written opinion, majority vote, super majority. You can say majority vote that must include the doctor's opinion. So really, our clients can customize this to whatever level of comfort that they need so that they know that if this time came, they really have a panel of people that they can trust and depend on to remove them from the position of trustee and protect them from themselves. We typically have some successor provisions in here. We try to account for almost any situation that we can fathom. So our documents are quite long, but there's a lot of reason for that. Okay, so moving past incapacity, another focus of our clients' estate planning is, and this might be the most obvious one, making sure that assets are distributed at the right time, in the right ways, to the right people, and in a way that is as easy as possible. That's usually one of the biggest things is the clients will say, we want this to be easy for our kids, our family, our friends. We don't want them to jump through a lot of hoops. So that's what we try to build into the planning, and really allow our clients to retain the levels of control that they want over how these distributions are going to occur. And that's done through good documentation, right? And again, I said that the paperwork is lengthy, but it's for good reason. And we want to do this all with fully disclosed and controlled settlement costs. So we're discussing these costs at each turn, each phase of the planning. So when our clients meet with us for the first time, the second time, the third time, and even in years thereafter, especially if they have questions about it, we would have discussed how settlement works, generally what the process is going to be, the paperwork that we're giving to our clients. It doesn't just do things magically, right? The paperwork doesn't float around to the banking institutions or the life insurance company and begin to collect stuff. There's an expectation that people are going to do work. Those people are likely yourselves, but also other professionals. There's going to be attorneys that are involved in the process. Very likely accountants will be involved in the process, maybe financial advisors. That's always nice when you can get some assistance there. So there's going to be a lot of people that are helping you to do the things that you're expected to do. And there's costs associated with that. So these costs are discussed with your family members when they're doing their planning. And we'll talk about shortly what we have as a formal maintenance program for our clients to come in each year and discuss their plan, review it, and make any changes to their plan. And those clients who do participate in that maintenance program, we actually make a promise to them in our fee agreement at the beginning. We make a promise to them to keep our costs low. So we have a fee arrangement with them. It doesn't obligate you to use our offices for the settlement phase. It just means that if you use our offices, we can't exceed certain caps and thresholds in our fees. That's our promise to our client who has made the efforts each year diligently to make sure that their plan is in good shape. So the Legacy Assurance Program is the program that we implement to make sure that a good estate plan is put in place for our clients. At the beginning, when they're setting up their estate plan for the first time, they are working with my team. Like I said, that's myself, Rich, and Cindy. And we consider ourselves counseling-oriented attorneys, meaning we are not sitting with people asking, okay, name, date of birth, kids' names, and plugging it into a simple form, and it's one size fits all. That is not at all what we are doing. We spend a lot of hours with your loved ones, typically on the startup phase, just to get the plan in place initially. We're spending about 8 hours of our time and their time too, putting this together, making sure it says what they want it to say, making sure that every customization, every provision that they can think of that they want to see in that document is going to be there. And certainly we've given guidance and advice and all of the things to make sure that it's going to operate smoothly on the back end. And then for those clients who do participate in our annual updating program, they're going to spend probably another 2 hours per year making sure the plan is still correct. And my office ends up spending probably, I would guess, about 5 hours per year making sure that their plan is up to date, incorporating any changes that they may have, any legal changes that may be necessary. So this is something we're working on for several hours each year to make sure this is going to work. And so what that tells us is that we are not just using a templated form and plugging in people's names. We do, like I said, offer a formal updating program. It is very likely that your loved ones are involved in that program. We do have a lot of enrollees in the program. I think we're over 400 client matters in the program currently. And it is just a really systematized way of making sure that if your loved ones do have any thoughts, questions, changes, whether it's changes to documents, changes to assets, or even if there was a legislative change that could affect their estate plan, every year their estate plan is getting a little bit of a tune-up, and we're just going to make sure that this is going to operate in the best way possible. And through our program, like I said, because we do make that promise right in our fee agreement for those people that participate in the maintenance program each year, we are assuring to your family, and hopefully that's going to trickle down as an assurance to you, that there are controlled settlement costs that have already been discussed. So through our program, some of the personal planning goals that we hope to address, clarity, like I said, that's usually a big one. People will come in and say, I want this to be easy. I want my family to be able to understand this as best as possible. Or I at least want them to know they have a point person. They can call Megan, they can call Rich, they can call Cindy, and know that when they make that phone call after I'm gone, or if they need help because I'm incapacitated, that attorney is going to be able to walk them through the steps. You guys are not expected to be attorneys. You're not expected to be experts or professionals. You're expected to know when to call, and then hopefully you can safely rely on the advice that we're giving you. And that advice is going to come from the documentation that your loved one has in place that we've done with them previously. Another planning goal for a lot of people is avoiding the cost of long-term care. Nobody wants to go into a nursing home, but unfortunately, the reality is most people end up needing some level of additional care, whether that's care in their home, assisted living, or nursing home care. That care tends to be very expensive. So when we're doing our planning with our clients, we're talking about this cost. We're talking about anticipating that need. How are we going to fund it and still preserve the most amount of the assets as possible? So a lot of our estate planning actually really focuses on protecting assets in the event that someone needs long-term care. What we typically see for long-term care in the area is probably somewhere between $6,000 per month. That's low-end care in someone's home, all the way up to and exceeding $17,000 per month for nursing home care. And so the nursing homes increased their daily rate this year, as they do every year. But the ones that I've been dealing with pretty closely, they're over $17,000 a month. So that's a hefty expense. And as part of regular estate planning, your parents, your loved ones could have already planned for that cost so that when the time comes, their assets are protected. They can make sure that there's something left over to go to you, even if they have an extended need for long-term care. Another concern can be some asset protection for a surviving spouse or for children or other beneficiaries in case the child themselves encounters any concerns or issues, whether it's creditor issues, divorce, remarriage for the surviving spouse, long-term care either for a surviving spouse or for children or grandchildren, etc. So we can create layers of protections in our estate plan, and we generally do recommend to our clients that they include the protection. They can include it in a very flexible fashion, giving the children the opportunity to take advantage of the protection if they want to, but they can also bypass the protection if the child does not feel like it's necessary. Or some of our clients can mandate this protection. They have an established concern and they want to make sure that this protection is going to be there for their children or other beneficiaries no matter what. So this is going to be something that as we go through the process and you deal with our office after your loved one has passed away, we're going to talk to you about those opportunities for protection and encourage you to take advantage of it if it is built in. And then certainly tax planning. So tax minimization, or hopefully it's something that we can mitigate completely. And in many cases, we can do that. So the planning that we're doing, while fewer and fewer people are especially focused on taxes because the estate tax exemption is very high currently, we do build in tax planning where it becomes necessary. For estate taxes, like I said, the exemption's quite high. In New York, for New York residents, it's $7.35 million is the exemption, meaning if someone passes away, a New York resident, in this year, 2026, and their assets are less than $7.35 million of value, they do not have an estate tax, not at the New York state level and not at the federal level either. The federal level is $15 million per person, so it's higher. So if you don't pay New York, you're not paying federal. Sometimes people fall between those two, and so we would have done some estate tax planning for them, or some even exceed the federal level, certainly, and we'll do some estate tax planning for them as well. When we're not focusing on estate tax planning, it actually allows us to focus on capital gains tax planning, making sure that when assets pass to the next layer of beneficiaries, they're getting an adjusted cost basis for those assets, often a step up in cost basis due to inflation. So we're trying to preserve some of the tax benefits where we don't have other tax issues to be concerned about. And that's going to be built into our plans as well. So we're trying to address all of these things. These are the most common concerns and goals that our clients are going to have. That's not to say these are the only ones. Certainly there can be more nuanced concerns, but these are the ones that I think are a little bit more universal. Okay, so coming back to the revocable living trust, the RLT, that's what we saw earlier, the blue box and the green box on the screen. Here we have an example of a joint RLT. So let's say instead of the Megan Conroy Living Trust, I set this up with my husband. It's the Justin and Megan Living Trust. We put this together. We still have the same incapacity provisions here. So we still are addressing if either or both of us become incapacitated, we want to have the panel in place. We want to have our incapacity trustees set up and ready to go in case they need to take over that position. But eventually, I'll kill off my husband first, unfortunately for him. If Justin passes away, then we have a bifurcation of the assets essentially here. And so what we typically will see in a very standard trust structure where it's a joint trust between spouses is we're going to build into the trust some different options. These options are addressing all of those things that we saw on the prior screen. So we have a portion of the assets will likely be allocated to either or both the marital and or the family trust. These trust structures are here to receive the inherited portion of the estate. So if Justin passes away first, everything in the joint revocable trust is pretty much considered 50-50. His 50% would move into either or both the marital and or the family trust. My 50% essentially stays put in this revocable trust structure. We just call it the survivor's trust to now distinguish that this is no longer a joint trust because one of us has passed. But this is still the revocable trust structure with the disability provisions and all of the other provisions that I set up. The inherited portion of the estate that I'm now receiving, I'm getting this from my husband, will go, like I said, into the marital and family trust. The family trust is typically the structure we're using if my estate, or really I should say my husband's estate, exceeds $7.35 million. If we have a concern for estate taxes, we can mitigate those taxes by allocating some of the assets, the excess assets, into the family trust. So the family trust is generally for estate tax planning. There are a couple of other uses that we can apply for the family trust. Sometimes it's helpful in a blended family situation. Maybe this is a second or third marriage, and we have children from prior marriages. Sometimes we'll use the family trust to address some of those concerns, make sure that there are funds immediately available to Justin's children from a prior marriage through the family trust. The marital trust, on the other hand, is not addressing any estate tax concerns for us necessarily. So anything that's not subject to estate tax is going to be allocated to that marital trust. The marital trust still benefits from capital gains tax benefits, that adjusted cost basis when the assets eventually flow down to the children. So as much as we can, we want to allocate assets to the marital trust because we can retain the capital gains tax benefits. Only assets that we have to put in the family trust due to estate tax concerns or maybe familial relationship concerns, those assets will go in the family trust. And we try to keep that, like I said, as little as possible because we do lose the capital gains tax benefit on that. These trusts, both the marital and the family trust, create protections for the surviving spouse. In case the survivor ends up encountering a lawsuit, there's some creditor protection there. In case the surviving spouse needs long-term care, there is some long-term care protection built into these trusts. And then also in case that surviving spouse finds love again and gets remarried, we don't want the new person that's entering the relationship to swoop in and somehow take over these assets so that eventually when I pass away, I don't want to leave everything to, I don't know, Jose from the cruise ship, right? I don't want to leave everything to him and now disinherit my children inadvertently. Or if it was Justin had children from a prior marriage, he doesn't want to give me the opportunity to disinherit his children that maybe I'm less inclined to leave things to after I've established this new relationship. So we have a lot of layers of protection built into these trust structures. My share of the estate, on the other hand, like I said, is still revocable. It's still flexible. I can change the ultimate beneficiaries for this portion. I can take assets in and out of the trust at any time. So I still have a lot of control and flexibility over the survivor's trust, my portion of the estate. So this is often a structure that we will see between a married couple if they are using a revocable living trust. There's also the irrevocable trust option, which we'll take a look at in a few minutes, has a fairly similar structure. It's actually a simplified version of this. We don't need as many layers of protection because the irrevocable trust creates a lot of protections at the outset. But the concept is the same. We can build in protections wherever it's needed. More of our clients are having joint revocable trusts than they did previously because the estate tax exemption is so high. Previously, so for clients that did planning long ago, if it was a married couple, they may have each ended up with a separate revocable trust, and those revocable trusts will have similar provisions to this one here. It's just that they're in two separate documents. Okay, so looking at what happens to this joint revocable trust after I eventually pass away. So I have the inherited portion that I received from my husband at the time he died, and then I have my portion that I still had left over, and I held on to that until the time I passed away. In this instance, we're using examples that we had two children. We'll assume they were joint children from the both of us. Here, we're going to pretend it's a 50-50 split between the kids. Now, we've drawn boxes for each of the children on this page to represent additional protections that we can offer to our children if we do want to take advantage of that. And we'll come back, I think, in just a couple of minutes to the protection continuum. But before we get too far away from it, I want to address the irrevocable trust structure. So like I said, on the prior pages, we're looking at revocable trusts. And I'll page back here. This setup for the kids can be done in both the revocable trusts and the irrevocable trusts. So the irrevocable trust structure is one that we often use. I would probably say maybe upwards of 85% of our clients end up using the irrevocable trust structure specifically for Medicaid, for long-term care planning purposes. And so the concept behind the irrevocable trust is, as I said before, it's a pretty similar structure to what we've seen in the revocable trust world, but it creates additional protections for the assets that go into the trust. Those protections are mostly geared towards the cost of long-term care. The function of the trust, the irrevocable trust specifically, is to get assets out of your loved one's names and into the trust structure so that down the road, if they need to apply for Medicaid, which is a government benefit, to pay for their long-term care, they can qualify. They can meet the financial criteria that the Department of Social Services mandates before they'll approve someone for long-term care Medicaid. So the irrevocable trust is one that shelters the assets, gives us asset protection in case someone needs long-term care down the road. The tricky thing with the irrevocable trust is that for long-term care for nursing home settings, there's something called the 5-year look back. So the trust has to be in effect and holding the assets for at least 5 years and a day before your loved one applies for nursing home Medicaid. That's the only way that irrevocable trust is going to be protective for nursing home level Medicaid. There's a note on this slide regarding other kinds of care, and we call it community Medicaid. That's referring to care in your own home and assisted living facilities. Technically, there is a law on the books that says that there is a 2.5-year look back period if you're applying for community level care. But they have really had the state has yet to enact that or enforce that, I should say. So right now, for those loved ones who are starting to decline, they need care in their own home or they need assisted living, we can actually get them eligible for Medicaid immediately. We can set up the trust here on May 28th, and starting June 1st, they can be eligible for community level Medicaid. There's no look back period that is enforced in the community setting right now. So it's just for nursing home Medicaid. We have a 5-year look back. It really is a 5-year look back. It's not 7 years. It's not going to 7 years. It's a 5-year look back, and that's if your loved one is applying for nursing home level care. We want their irrevocable trust to be in effect and funded, holding the assets for at least 5 years and a day for that trust to truly be protective. So the irrevocable trust is protecting the assets because of some specific restrictions that are associated in the language of the trust. Namely, the trust paperwork has to say it's irrevocable. The fact of the matter is you can revoke an irrevocable trust. So if someone doesn't make it through the 5 years or their circumstances change dramatically and they determine that they really don't need Medicaid to pay for their care, then they can terminate that irrevocable trust. But otherwise, it's going to be irrevocable on paper, and that's how we're going to treat it for as long as they're alive and needing that protection. The irrevocable trust also has to have a provision in it that describes that the trust maker cannot retain direct access to principal of the assets inside of the trust. So once they set up the trust, let's say I set up the Megan Conroy Irrevocable Trust, I do that today, and I put my house in there, and I have a savings account with $100,000 in it. I put the $100,000 into the trust. I go down to my bank. I tell them I want to change the ownership on this account to name the Megan Conroy Irrevocable Trust as the owner. I put the $100,000 in the trust. That $100,000 now is off limits to me. I can't go down to the bank and say I'd like to take $5,000 out of that $100,000 trust account. That principal is not available to me. If that account, instead of being in a savings, is invested within the trust and it's earning income, interest, dividends, I can withdraw the income that's being produced by that account, but not the principal. If I really needed to access the principal, the provisions of my trust will say, well, Megan can't distribute principal to herself, but Megan can distribute principal to her children, her brother, any adult person that you can count on, right? And that allows me to distribute some of that $100,000 to, let's say, an adult child I have, and I'll have a conversation with them. I'm going to give you $10,000 out of the trust, but after that clears in your bank account, you're going to feel very generous and you're going to give me $10,000 back. And we create a little bit of a loophole that way. So if your parents ever make that call to you, expect that they're going to be asking for that money back because they might be using the loophole. We like the irrevocable trust because it creates the asset protection, but it allows my clients to retain control over the assets. So they're not worried about, well, I gave this account to my daughter and then eventually she turned around and backstabbed me and didn't, take care of me in the ways that I thought. And now I have no way of getting this money back. Not always the case, certainly, but it could happen. Or even worse, I gave it to my daughter, but then my daughter ended up having a creditor issue or ended up getting a divorce, and now my money is going to be subject to her liabilities. Also, if you give assets that are appreciated to other people, adult children or anyone else, you're actually you're sacrificing the capital gains tax benefits that they would have gotten had they just inherited those assets. So for instance, if I give my house to my adult children and I paid $50,000 for my house way back when I give that house to my kids, the government treats it as though my kids paid $50,000 for that house. So after I'm dead and gone, they sell the house for $550,000. The government's going to say, wait a minute, you just profited to the tune of $500,000 and we're going to tax you a capital gains tax on that. That capital gains tax is not an issue if instead I moved that house to a trust and then my children waited to inherit that property until after I've passed away. So the trust is really addressing all of the concerns that our clients typically have without sacrificing any of the benefits that could be associated with it. So this image is what an irrevocable trust structure could look like. Frankly, like I said, it's pretty similar to the revocable trust. We have the trust document set up here. This trust document is going to incorporate all of the incapacity protection provisions that we would want it to address. We are getting long-term care protections here that we were not getting in the revocable trust structure. And then it's also going to work to distribute our assets to our children or other beneficiaries, and we can set that up to go to them in a way that's protected for them as well. So we have all of the same opportunities here. This just does a little bit more heavy lifting than the revocable trust structure. The reasons that we like the trust structure here, and even the revocable trust, but especially this one, is because we are creating asset protection for our clients. We are creating potential for asset protection for their children, and we're also avoiding any probate proceedings. So when the assets are passing through the trust, whether it's this or the revocable living trust, there's no probate, there's no court proceeding that's going to occur for the distribution of these assets. It's all privately handled between the trustees and the professionals, the attorney, the accountant, the financial advisor, which means there's less expense associated with it. There's less delay associated with it. It's a lot easier process. Okay, so just touching on the protections that we can create for the children. If we did not create protections for any kids or beneficiaries, we would be on the outright side of distributions. That means if I'm inheriting an estate from my parents after they pass away, outright distribution would be, okay, check made payable to Megan Conroy. They hand it to me, I deposit it into my regular old bank account, and while I have the funds, they're not protected in case I ever get sued, divorced, if I ever need any government benefits like Medicaid, anything like that. So I still get the inheritance, but I don't get any of the added protections that we might want to create for a beneficiary. And the outright distribution can happen in a few different ways. But typically for our clients, where we like to be in our planning continuum here is an in-trust distribution. So you may have trusts set up for you. So when you get your inheritance, you get the inheritance in a way that is protected for you in case you do get sued, in case you do get divorced, you need Medicaid down the road, anything like that. Your parents, your loved ones are giving you the added gift of protection. So we have a few different variations of the kinds of trusts that can be available to our beneficiaries, to our children, and which kind of trust your loved one used is going to be based on conversations that they've had with us to tell us what your financial abilities are, what maybe your history is, if you've had some concerns in the past, how much protection do we want to build into this versus flexibility. Most of our clients do have what we'll call lifetime protective trusts, meaning this is the most flexible version of the trust. You can invest the assets, manage the assets, do whatever you want with your share of the inheritance within the trust. You can withdraw the assets, spend them however you like. But if ever you had any kind of issue in your life, a lawsuit, divorce, etc., the assets inside of this trust are protected. So it doesn't feel like there's any restrictions. It doesn't feel like there's a trust, but there's like this invisible barrier that creates that protection. And then we get a little more restrictive as we continue down the spectrum. There is the supplemental needs or special needs trust option for our clients who do have children or beneficiaries who are already dependent on government assistance in some form, whether that's Medicaid, SSI, SNAP, HEAP, those kinds of benefits. They don't want their child to receive an inheritance and then all of a sudden that child loses all their benefits because of this inheritance. So this special needs trust actually allows that beneficiary to keep their benefits and receive the inheritance that they're expecting. So that's our protection continuum. We prefer the in-trust portion of things, so you are likely to see that coming to you at some point in the future. And depending on what kind of trust structure it is, you might have more flexibility or less flexibility. Okay, so now I'll just take you through our process. This is more of the how-to and what to expect. And we might be a little bit after 6 o'clock on this. So again, if you have to jump off, that's absolutely fine. I see maybe there's a little note in the Q&A here. Okay, and so there was a question about the difference between a revocable trust and irrevocable trust. And I know we just touched upon that a little bit, but just to summarize again, the revocable trust, the primary benefits are planning for incapacity, so a streamlined transition of control in the event that there's incapacity of the client, of the trust maker, and also distribution of assets in a way that avoids probate. The irrevocable trust is going to add a layer to that. So it does all of those things, but it adds in some protection for my client while they're alive if they're needing any kind of long-term care, or maybe it's protection because they have tax concerns, things like that. So in the irrevocable world, we're looking more at protective provisions and less flexibility to the client. That tends to come with restrictions. Both trusts can technically be revoked, like I said. So even in the irrevocable structure, changes can happen and even it can be revoked. And I apologize for the delay on that. So certainly feel free to type in more questions as we go. Okay, so I'm going to go through our process here. So this is pretty much what your family members have gone through right up until the settlement phase, of course. So they met with us over a series of probably somewhere between 3 and 4 meetings. We do offer a family team meeting for those clients who want to have their children or other professionals sit down with the attorney and hear like a bird's eye view of the kind of planning that they've done. So more specific than this, your family members are still welcome to set up this one-on-one meeting for that maybe more detailed discussion. Then they're likely participating in the year-to-year maintenance program. So they're updating their plan, making sure things are still working correctly. And then eventually, if they became incapacitated or passed away, we would be at the settlement phase of the plan. So it's lengthy. There's a lot of touch points between us and our clients. We do try to make sure that any questions or concerns that they might be having are addressed, because if it's being ignored, it likely means that an important part of the document is not going to be doing what it needs to do. So there are certain roles that we're going to designate helpers in. Certainly there's going to be healthcare roles in the event that our client loses capacity or loses the ability to continue to make healthcare decisions for themselves. One of these I've already talked about, the incapacity panel. That's in the revocable living trust. If the panel members determine that the trust maker really should not be managing their own trust, their own finances anymore, this incapacity panel can remove the trust maker from the position of trustee so that they don't have that ability to manage those finances in the trust. There's also the agent in the healthcare proxy. That's different. That is who can make a healthcare decision for your loved one if they're unable to make their own healthcare decisions. So again, it could be complete incapacity. It could be that the doctors have concerns that they might not really be getting that general understanding of the issues at hand and what the options and procedures might entail. So then you might be called upon as a healthcare agent in the healthcare proxy. And then the last one is a guardian. Now, all of our planning is doing everything it possibly can to avoid a guardianship proceeding. A guardianship proceeding is a court proceeding, and it's a last resort. It's if someone loses capacity and either doesn't have any other planning documents in place to designate who takes over when they can't do it anymore, or very rarely, but sometimes it comes up, when not our clients, but when people don't have this incapacity panel mechanism in place and their family can't stop them from being susceptible to the scammers. And so that does come up from time to time. The only way to take someone's power away from them is if you go through a guardianship proceeding, or in the alternative, they've put in their documentation that if this certain criteria is met, my panel can take my power away from me. And so our clients will often have that provision. And hopefully we avoid that guardianship proceeding. For financial roles in the event of incapacity, we're going to rely on our disability trustees, or also sometimes known as an incapacity trustee. And we're going to rely on our agents under a financial power of attorney. The difference here is the incapacity trustee has the ability to manage assets that are owned by the trust. Okay, so trust assets only. The power of attorney then is going to give the agent the ability to manage assets that are outside of the trust. All of our clients are going to have some combination of assets in the trust and assets out of the trust. That's part of the strategy. It will depend heavily on the kind of assets that we're dealing with, the client's goals, and the kind of trust that we are using. Certainly with the irrevocable trust, because of the restrictions in order to get the protection of that trust, we're going to put fewer things into that irrevocable trust so that our clients still have access to funds to pay the bills and to take the vacations and do all the things. So you're going to want to know, are you a successor trustee for incapacity? And are you an agent in the durable power of attorney? Those are both financial roles. So here I just have a little excerpt of some of these planning roles and kind of what's involved in it. So you're going to see the disability panel, the financial power of attorney, the healthcare agent is the healthcare decision maker, guardian if we have to resort to that, but hopefully not, and certainly disability trustees in the trust structure. So determining disability, if you have concerns about your loved ones, typically you will likely contact my office since we have the planning documents. You're probably going to want to know what to do, what the steps are to take, and what documentation actually exists. Is it a revocable trust, an irrevocable trust, and all of those things. So you're welcome to contact us and explain to us what the concerns are. Typically, we will try to verify that with our client directly if we can, if it seems feasible. But depending on what's going on, obviously that may not be available to us. And so then we'll resort to going through that paperwork with you and providing you with what it is that you might need. If there is an incapacity panel in their documentation, we're going to engage the incapacity panel. So we're going to describe to you how to do that, who's involved, how to contact those people, and the paperwork that's going to be involved to making sure that we have good support for determining this person's inability to serve as the trustee. That paperwork is going to include certificates of incapacity, typically from all the panel members, and often a doctor. And it's like a generic my attending physician. We typically want their most current doctor to evaluate them and say, yeah, you know what, this is probably not a good idea anymore. They probably should not be managing finances. And the doctor will also sign one of these certificates. So this is an example of what that certificate of disability could look like. It just says, I am a member of the disability panel for this person, and we cite the exact provision of the trust. I've consulted with their doctor or attending physician and fellow members of the panel. And based on our observations, the opinion is this person is incapacitated, disabled, and that will result in his inability to effectively manage his property and financial affairs. So we have these set up, ready to go in case we do need to use them. It's just a matter of getting all the right people together to do it and getting the paperwork signed. Okay, so some of the procedures during disability. There may be the requirement of transferring assets depending on what's happening at the time and where the assets are at that point. But we're going to want to see what assets exist, where things are. We're going to do a complete review at that time. So especially if you're going to be the financial agent, you're going to want to know about these assets and know where the bill pay accounts and what kinds of expenses are they experiencing and how are we going to stay on top of all of this stuff. If there is a trust involved, and very likely there is, there's going to be paperwork that you would sign saying, I'm ready to take over the position of the successor trustee now that we've determined my loved one is incapacitated. Even though you're named, you are not forced to serve in that position. So if you're feeling uncomfortable about this, or you're at a point in your life where you can't take on this added responsibility because it is big, you can say, I don't want to do this. So if you do want to accept that role, you're going to sign documentation to that effect saying, I understand what my responsibilities are and I'm ready to do that. The paperwork that you're signing is going to help you to do your job because every banking institution that you deal with is going to say, well, how come you're coming in, right? You don't have authority over this account. I don't see anywhere that you're named. So you need to have paperwork ready to show to them, I took over the position of trustee for these reasons. The trust said if they lose capacity, I'm up next. We've established they've lost capacity and I took on this role. So there's going to be paperwork to prepare that will make your life a lot easier, that allows you to accept that role and responsibility. So this is an example of what that paperwork would look like. Here we have an affidavit of trust. It describes all the basic details, how we got to you, right? The name of the trust, the important provisions of the trust, and what happened in the interim that put you in a position where you're going to take over that management. And typically you're going to sign and this will be notarized. And this is the paperwork you'll carry with you along with some attachments from the trust to be able to support the fact that you do now have authority. At that point, once you have authority, your job is not done, right? You have all the work that you have to do. So you're going to have to manage the assets. You're going to have to do it in a way that you believe your loved ones would have wanted. Some of that guidance is going to come from the trust structures. There's going to be language in there that describes things they want to continue to enjoy and kinds of distributions you're allowed to make. This is the stuff my office or any attorney's office who you're working with is going to tell you what to do and what you're not allowed to do, especially. There is the opportunity to delegate powers when there are multiple trustees serving. Typically, that language is going to appear in our trusts. So if I have someone who says, I want to appoint both my son and my daughter as my successor trustees, if I lose capacity, the time comes, they lose capacity, both kids are serving, they both want to serve, but then all of a sudden the son gets a promotion at work, he's super busy, he can't do nearly as many things as his sister can do. He can delegate some of his power over to his sister. He's not giving up the role, he's just saying for these certain kinds of transactions, I want my sister to be able to do this without me, and that way I can focus on what I need to focus on. Like I said, importantly, you're going to have to follow the instructions as outlined in the trust, and every trust is a little different. So you're going to have to at least become familiar with what you're allowed to do and what you're not allowed to do. And you do have a fiduciary responsibility, meaning you have to do your best to act in your loved one's best interest. You do your best to follow their instructions and their wishes. Typically, I'm dealing with regular people. These are not attorneys that are coming in or financial advisors that are coming in to help their parents in these roles. So you're not, you can be, you might be, but you're not expected to be very sophisticated in these things. But the obligation is don't do anything that you know to be harmful or malicious, right? You do have a responsibility to try your best to follow these guidelines. So this is some of the guidelines that we've pulled from an example of a trust that describes to the trustee the kinds of distributions they're allowed to make when they take over in an incapacity setting, who they can make distributions to, for what purposes. So these are the guidelines that you'll become familiar with at that time. We do tend to try to keep them pretty broad so that you have the flexibility to manage the assets and make distributions in ways that you think are appropriate for your loved ones. So typically you're not going to find a lot of restrictions in here. The irrevocable trust will be the most restrictive. You'll just have to remember not to distribute principal out to your parent or loved one. That's going to be usually the biggest barrier. But the rest of this is going to serve as guidance. This is just an example of if the trustees needed to delegate powers between them. So I gave the sister-brother example. The brother can't do certain transactions or can't be as involved right now. He can delegate his power to the sister. And so this is just some sample language that we would pull directly from the trust that authorizes him to do that. And we have paperwork that we would prepare to solidify that delegation so that the sister can go around and say, I know my brother's name is on here, but he gave me this power. He delegated the authority to me, so you can listen to just me or allow me to sign the checks without him for the time being. Continuing talking about asset management in the role of that disability trustee, there might be some specific concerns that we do have to be careful of. Namely, if we have concerns about long-term care and eligibility for Medicaid, we want to be very careful about gifting. You don't want to start making gifts because the trust technically says you could make gifts without checking in with the other professionals, because if the trust says you can make gifts to other people, but for Medicaid purposes, the gifts would be a problem, you don't want to be caught between those two dynamics. Also, retirement accounts tend to be tricky, especially if your loved one is of the age where they're required to take required minimum distributions. You, as the agent in the power of attorney, are going to have to make sure that they're taking those RMDs, because if they don't take them, if you didn't realize or you forget, they're going to get hit with fines and penalties for not having taken a required distribution. So you're going to need to know details about the retirement accounts and what they're required to take and what they're not. So often you're going to work with the professionals, the attorneys, the financial advisors, the accountants to make sure all of these pieces come together for you. You kind of understand how this is all working. For healthcare decision making, so if you're put in a position, not so much financial, but where you need to make healthcare decisions, you're going to refer to the healthcare proxy. Sometimes there are written instructions in that healthcare proxy. You're going to refer to any verbal instructions that your loved one has given to you. So maybe they just said off the cuff one day, you know what, if that ever happens to me, like Aunt Susan, just let me go, pull the plug, right? That's an indication that they don't want life prolonging care if they're in a point where there's no chance of recovery, it's a really poor quality of life. And those are things that you should just keep in mind when you are making healthcare decisions. Often our clients sign a document called a living will that expresses those exact wishes in writing so that you don't have to try to drum that up from memory. You can then look at the paperwork and see what exactly they wanted under what circumstances and criteria. So that living will is going to be a really important document for you to look at. This is an example of the living will provisions. It describes when it goes into effect, under what criteria. Usually it's a permanent vegetative or comatose state with no chance of recovery. If they meet that criteria as determined by either one or two doctors, and the living will say that, this one says two, then there are certain kinds of care and procedures that should not be performed. And this document describes it as those procedures that would only serve to artificially prolong the dying process. No chance of improvement, not good quality of life, not a good outlook, then we don't want to give life prolonging care. This is an example of a healthcare proxy. So this is where the designation of who's going to make those healthcare decisions will appear. Typically, we see agent information on the first page with backup agent information on the second page. If they put in any specific wishes or instructions to you, that will appear on the first page as well. Sometimes it does have an indication about how they feel about organ donation. If there's nothing in there about organ donation, they're leaving it up to the agent to make that decision on their behalf. Otherwise, you have to follow the anatomical gifts selection that they've made in the proxy. Okay, so what happens now? We've gotten through incapacity and eventually they pass away. What are the rules? What am I expected to do? There's the distribution rules, right? So this is who's going to handle the financial component of this for making sure that the assets get to the right people. Ideally, we're only dealing with the death trustee, the successor trustee provisions, and we are not dealing with an executor. However, if there are assets that were not associated with the trust, there's no surviving joint owner listed on the asset, and there's no beneficiary listed on the asset. That means that asset is kind of just floating around. There's nobody else connected to it. Then we will have to probate the will, and our clients all have wills. We'll probate the will, which is a court proceeding that takes about a year from start to finish. We probate the will for the executor to be appointed by the court under the will, and the executor has the authority to collect those assets that had nothing else and no one else associated with it. So we could have a combination of both. We like to see for our estate plans that we're only using the trust and we don't have to resort to the executor, but sometimes it ends up being a little bit of both. So the immediate tasks after someone passes away, all of our estate plans that involve trusts have gone home with our clients in a red binder. Okay, it's like a burgundy color binder. It's pretty big. It could be multiple binders as well, depending on what their plan looks like. I think it's a good idea for you to know where the red binder or where that important paperwork is stored in their house so that you can access it in an emergency, in the event of their incapacity, after death. That binder should have all of the necessary paperwork in it. They leave with a set of originals in their binder. We have a set of originals here in the office. If the binder can't be located, we can provide you with our originals, but we're very cautious about doing that because that means that that's the last set of originals that we're aware of that is walking out of the door. So we prefer you know where the red binder is so that you can access those materials. It's fairly well organized, assuming your loved ones left it organized. So you should be able to flip through and pull out what you need. If there is an organ donation selection on the healthcare proxy form, You're going to want to make sure you're aware of that if they're hospitalized so that you can make this decision if it came down to it. We also include a form, it's called a disposition of remains. That's going to serve as guidance to you for when they pass away. What did they want to happen to their remains? Did they want traditional burial, green burial, pod burial, cremation, human composting, water cremation? There's a trillion options out there. So this is going to describe to you what they would have wanted. They may have already pre-planned and even prepaid for some of these things. We do encourage them to do that. So you're going to look for this document to help guide you for those final decisions. And then you call the law firm, right? If you can do all these other things, you don't have to call us right away. You don't have to call us when mom or dad is taking their last breath. We don't need to be brought in that soon unless you have major concerns or questions. But typically after someone passes away, you get through the final services, memorial services, funeral, etc. As the dust settles a little bit, you say, okay, now I'll make an appointment with the attorney's office to figure out what it is we're supposed to be doing. There generally is no formal reading of the will. A lot of people think it happens like it happens in the movies. Typically not. Typically, we're meeting with the family members who are named as the successor trustees or as the executor so that they start to understand what's involved, what their tasks are, what kinds of things they should be gathering and looking for. We typically are not bringing the whole family in to sit around a big table so we can tell them what they are or are not getting. It doesn't generally happen in that fashion. So we have a checklist of initial tasks and things to look for and consider. One of those things that you should look for in the binder is a more elaborate version of what they wanted for their funeral arrangements and services and wake and things of that nature. And it'll also describe to you some of the documentation that you should start to gather to be prepared for next steps. The funeral home will provide you with the death certificates. People usually order about 10 of them. Typically, the funeral home will notify the Social Security offices as well. So after we've moved past the funeral, final services, and you do meet with the attorney, some of the things you should be prepared to collect, again, asset information. If you can collect statements for assets, that's best. That way we can verify that all the assets are titled as we expect them to be or have beneficiaries as we expect them to have. There's going to be debts and expenses. I don't really want you to pay those necessarily immediately. The funeral certainly should get paid for if at all possible, but everything else, just collect information about debts and expenses, and we can sift through and see what needs to get paid and what maybe doesn't, because there are expenses that don't need to get paid under certain circumstances. And so if you just gather the information, we can sift through that with you. Certainly things like taxes do have to get paid, unfortunately. After someone passes away, the following year, you have to remember to check in with an accountant to see about filing a final income tax return. So if I died tomorrow, my husband in April of next year needs to talk to our accountant to say, well, while she was alive in, the 5 months or so that she was with us, these were her earnings. And then I need to, or he needs to, on my behalf, report that for me. So don't forget to do that. There could be some other taxes that we need to address, but often income taxes will be the big one. So you're going to gather that information. You're going to meet with the law firm. Typically, at that point, we're going to tell you about what it is you're going to need to do, get some of the paperwork in order, prepare the affidavits, delegation agreement if that's necessary. We'll probably get a tax identification number for the trust at that point. So there's nothing you have to do or your accountant has to do. We will get that tax ID number if there is a trust involved, and we'll provide that information to you. This is an example of some of the paperwork that we would prepare to demonstrate that now the trust maker, our client, has passed away and you've taken over the role as the successor trustee. So this shows your responsibility for collecting and distributing those assets. So when you're working with financial institutions, you have something, again, to show them, to show why you're the one contacting them and it's not your mom or dad anymore. If we determine that there is probate necessary because there were assets that weren't connected to anyone or anything, we'll start the process of filing that probate petition with the court. We're looking for letters testamentary. So if a financial institution tells you you need letters testamentary, it likely indicates that this is a loose end. This was an asset that was not otherwise connected to the plan, and we need to go through probate. After the letters are issued, that's when we get a tax ID number for the estate account. And then that's when we're going to walk you through the whole year-long process for collecting assets, paying off debts and creditors, and then ultimately distributing the assets to where they need to go. Some things that you're going to need to be conscious of when you're making distributions of assets. So once you got that far, typically in the trust, the will, or later in the binder, there's going to be sort of a special stuff list. Our clients are given the opportunity to talk about household items, maybe of sentimental value or monetary value, that they may want to be distributed in certain ways. So my wedding band goes to my son and my engagement ring goes to my daughter, that kind of stuff. Also, in our documents, we typically will include provisions for pets if our clients have pets. So that will be an immediate need. If you know your parents or loved ones do have some living animals in the house that need to be taken care of and addressed, there might be some paperwork on what they wanted to happen in that instance. So we'll look for that as well. And then once we see exactly where everything needs to go, that's when we can begin transferring assets. Typically, we like to transfer the assets to the appropriate beneficiaries in one shot, not piecemeal, but sometimes things happen differently. Before anything gets transferred to a beneficiary, we'll want to describe to the beneficiary what they can be expecting from the estate, and we'll have them sign a receipt and release saying, I understand what the assets are, that I'm getting this amount or this percentage that equates to this dollar value, and I'm okay with that. They sign that, and then we make the distribution. So we want to make sure everyone is on the same page before we start handing out money in case there is some concern or there was something overlooked. And then we don't want to have to go around and ask everyone to give back a little money to account for this error that was made. So we wait to make those distributions until everything is accounted for. This is an example of what the special stuff list could look like for tangible household items to go to certain people. So it can either be in the trust document, in the will document, or on this separate memo. You're going to want to check all three. Okay, so just quickly, administration for different kinds of trusts that you might encounter. Joint revocable living trusts, like we said, we could have to establish a marital or family trust after the death of the first spouse. We would get tax ID numbers, prepare an affidavit. We might need to obtain asset values at that time. It's usually a good idea to get some appraisals done. Whether or not there's an estate tax issue, it helps us for capital gains taxes later. So that might be something you're directed to do. And then if there is an estate tax issue, we need to file returns. For distribution to other beneficiaries, if we do have trusts created for our beneficiaries, we're going to set up the affidavits and get tax ID numbers for the trusts for our beneficiaries. That layers in that protection as a reminder. And then again, we try to describe to the beneficiaries the structure, what they can expect, both with the trust and the assets. And if they're okay with that, they're going to sign off on it before we make those distributions. So this is just another sample affidavit of what it could look like if we are creating trusts for our beneficiaries. Again, it's to make our beneficiaries' lives easier so they have something in one spot that demonstrates what they have, what the assets should be titled as, the tax ID number, etc. Like I said, they're going to sign off on the receipts and releases. That's a very, very important component of all of this. If we are encountering a dispute or we're going through a probate estate, then typically we're going to have either an informal or judicial accounting, which is a bigger undertaking. It's a lot more precise version of accounting for assets and expenses. And again, we're going to have correspondence to all the beneficiaries to describe to them what's going on, what they can expect from the whole procedure. Okay, so that's the review of what you might encounter if something happens to any of your loved ones. Let me just stop share here. So a lot of it, like I said, is we do like to operate with trust structures, but typically we'll see either revocable and or irrevocable. Sometimes it's a combination of those things. We are building in protections for incapacity, disability for our clients. We're providing for distributions to their intended beneficiaries, and we can layer in protections for those beneficiaries as well. Unfortunately, what that means for you is if you are involved you're probably going to at least call my office one time, and it's okay to do that, even if you don't want to use our services, just to get some basic information and documentation. And then the attorney's office, whether it's myself or someone else that you're using, is going to walk you through the process. There's a fair amount of paperwork involved. There's a fair amount of legwork involved. So it's really good that you're joining me here to get a sense of what would be expected of you so that you're not surprised at that 11th hour when your loved one is sick or they've just passed away and now you get piled on with, I have all this work to do on top of it. You'll still have the work, but at least it won't be a surprise to you. I do just want to check here, make sure if I had any other questions. Okay, it doesn't look like there's any other questions in the chat box. One more. There was a question about a provision that's called a trust advisor. That is not really associated with anything that you guys are typically doing, but the trust advisor is a provision that's included in most of our trust instruments. It builds in additional flexibility for those trusts. If it's an irrevocable trust, it builds that flexibility in because that trust is not flexible for our client. They can make certain changes, but then there are other changes that they can't make. And if they need to make those changes, they can, through a third party, a trust advisor, direct the advisor to make those changes on their behalf to their documentation. In a revocable trust structure, we typically don't see the trust advisor used unless the trust maker loses capacity or passes away, and it's determined that there are necessary changes to the technical parts of their documents. So we can't change beneficiaries or anything with that language, but if there's a change in legislation and the trust is outdated and now the person who created the trust is incapacitated or deceased and can't make those updates themselves, then the trust advisor can be a tool that's used by the trustee to update and refresh that paperwork to comply with those new legislative provisions or tax provisions or whatever the nuanced situation is. So it's an independent person, usually an attorney. I've served as a trust advisor, can be any attorney here in the firm or any firm of your choosing. Sometimes it's an accountant. They have to know how to draft legal language to make the appropriate changes, and they are a resource to the trustee in case there are some necessary changes and the trust maker didn't get a chance or opportunity to make those changes themselves. All right. Okay, guys. Thank you again so much for joining me today. I'm sure there are going to be questions as you process this information. You are always welcome to reach out to us with those questions. We can't discuss specific details of your parents' plan with you unless your parents give us the express authority to do that. So if it's more of a general question, like what's the trust advisor, certainly we can answer that for you and give you a sense. But if it's something that you feel like you're going to need some more details, we're going to need to talk to your parents to get that permission, as long as they still have capacity and can do that. Feel free to reach out to us with those questions. If you need, again, a copy of the presentation, we can get that to you. And then, like I said, this will be recorded. So if you needed to replay it, I don't know why you would want to listen to me any further than what you have. But if you needed to replay it, certainly you can do that as well. Thank you again. And I hope you all have a wonderful night. And like I said, reach out to Rich, Cindy, or myself if you do have any questions. Thanks so much, guys. Have a good one.